Welcome to Different Perspectives. I'm Paul Ndiho. Uganda's parliament passed a controversial bill giving military courts the power to try civilians, defying a Supreme Court ruling that banned the practice earlier this year. Opposition lawmakers are furious. They say the law violates Article 92 of the Constitution, which prohibits a parliament from overturning court decisions. The bill allows civilians to be court-martialed if their actions are tied to military operations. It also requires judges in these tribunals to have legal training, but critics argue that this is a dangerous policy. For more perspective, I spoke to Henry Muguzi, a political analyst and coordinator of the Africa Elections Observer Network based in Kampala, Uganda. Welcome to Different Perspectives.
Yeah, thank you, Paul, for having me.
The Ugandan parliament officially passed a bill that is about to be signed by the Ugandan president into law, basically saying that giving military courts the powers to try civilians who, quote-unquote, are quote engaged in military activity of any kind. Bring us up to speed. What is this all about?
Actually, Parliament passed two bills. The Uganda Peoples Defence Forces Amendment Bill was one of them. It was such a huge bill. The volume of the papers was 130 pages. And then there was the Political Parties and Organizations Amendment Bill. Those bills were presented, discussed, and passed in a period of just 1 week. So the haste with which this has been done leaves a lot to be desired. Uganda People's Defence Forces Amendment Bill was in response to a ruling by the Supreme Court, which had ruled that the idea of charging and prosecuting civilians in military courts was unconstitutional. And one of the bases for doing that was that the men and women that constitute the bench in the military court martial are people who have never set foot in law school. And yet these are people that we are supposed to make a judgment over life and death, because some of the criminal cases would call for the maximum sentence of hanging. And so based on those, the government moved very quickly. But you would imagine that government was very uncomfortable with that ruling of the Supreme Court, because first of all, that court was one of the tools being used by the government to gag and stifle, but also subdue political opposition. The Supreme Court had also ruled that the cases that were under the military court at the time of passing the judgment should actually be transferred to the civilian courts that are competent. And of course, the only case they did so was the high-profile one of Kizza Besigye and his colleague Lutale. But the rest of the cases were never transferred. But also, there are a number of youth who subscribe to the opposition national unity platform that have been incarcerated, charged on very flimsy cases, but of course charged under the military court martial and are being kept there. Both those bills were intended. There is a purpose, and that purpose is going to be for this election, and it was perishable, which is why they had to move very, very quickly and how these bills passed.
Let me go back to the point you made earlier. You talked about how this law could be used to target some opposition members. So are you suggesting that it's going to be retroactive? It can go back to some of those cases that have already been transferred to the civilian courts. They might withdraw those cases and take them back to the military court.
Especially the case of Kizza Besigye. Because according to civilian law, if you have been in incarceration for 6 months, you are entitled to bail bail unconditionally. So as we stand now, Kizza Besigye is about to make 6 months in jail. And already there was agitation to get him out, to asking the courts to release this man, because that's what the Constitution says. So now this act had to be passed, this amendment bill had to be passed quickly, so that then the court martial can go back and say, look, this was our case all along. You don't even have all the evidences. We have all the ingredients of this case. So most likely they will go and take it away from the civilian courts. What can happen is this one. The civilian court will release Kizza Besigye and his colleague, and before he leaves the precincts of court, he will then be rearrested and taken back to court martial, because this is the same playbook that we have seen for the last 2 decades.
How about people who argue and say that maybe the laws that govern the country needed to be amended and changed, and therefore that's why the government decided to go through the right channels, go through parliament to amend this law, propose a new law that is going to end up being signed by the president?
The government of General Museveni is not a government that wants to be understood as one that completely does things that are outside of the law. So it's a government that operates within the law. So they had to find a way within the law of regaining what they had lost. So this is what is happening, because they don't want to come up in some sort of kangaroo style. So that's why they had to let the law take its course. So these are the circumstances. But also I think we need also to a little bit condemn our colleagues from the opposition, because they did not help out. I think, it is not proper that they should always walk out when there is a contentious issue that they will lose. At least you get to be on record. Because now I know that there are plans to go to court and challenge that bill. And I will tell you that the president is going to assent to it immediately, because that is almost a formality, because it restores the status quo. So he will, I'm sure he's already itching to bring it and sign it. So he will sign it immediately. He gets it.
What does this say about the separation of powers? We are talking about earlier this year, the Supreme Court of Uganda, the highest court in the country, decided that all civilians should be tried in civilian courts, right? Not in military courts. But here we have another branch of government deciding to actually pass a law that sort of reverses what the Supreme Court had already decided. How can Ugandans, ordinary Ugandans, people like you, opposition guys, how can they cope with this?
Parliament has passed this bill against the spirit of the Supreme Court. But also you ask yourself, even these the members of parliament that subscribe to the ruling party, are they human beings? Do they have the country at heart? Because you see, once this law is passed, it does not always follow that it will only be weaponized against political opposition. It could also be weaponized against the very members of parliament from the ruling party that passed it. And we have seen this before, because there was a time we had a character we called Spam Minister. His name is John Patrick Amama Mbabazi. When he was Spam Minister, he passed the law, the Public Order Management Act. And the moment he stepped out and he tried to stand against the contest against the president, it was the very same law that was used to stop him at the Owen Falls Dam Bridge. He couldn't cross. These are each of us categories of society in this country has taken some share of the blame. But the thing is that the independence of those institutions, because you see that Parliament itself does not seem to be acting independently. It seems to be existing in captivity. and the captor is the head, the executive, because the executive has been seen to buy, to pay the members of parliament to pass legislation that would otherwise not have passed in any NSN parliament.
So are you suggesting that there was some kind of quid pro quo in this case where the executive wanted this bill passed, and therefore they gave something small to the legislators so that they can pass it?
A couple of weeks ago, there was a handshake of 100 million shillings. So each of them bagged 30,000. This 30,000 was not wired through the accounts. So it did not go through the banking system. It was picked in cash. That is the red flag number one. Because always it is only dirty money that is moved in cash, because clean money goes through the banking system. Secondly, the president came out and said that he did not deny that it came from him, not from government, but from him personally. And so we kept asking, why is he being so kind? So when you looked at around that time, what the MPs had done to deserve that handshake, it was not yet there. So it was scratching their backs before. Maybe they are the ones now scratching his back, because he scratched theirs prior. Now they're scratching his back by passing this bill. So the bill has passed. The power is right back into the hands of the regime. They can actually charge citizens into the military court martial, this time within the law. Because previously there was that contestation, oh, it is not within the law, there's this, there is that disqualifies military courts from being courts because they're lacking competent judicial officers. Now they're saying, okay, there shall be competent judicial officers. So what are you saying? We return them. That's where we stand, and it is not a pleasant situation.
Earlier, you talked about how opposition did not do their part. In some cases, they did not put up a spirited fight. They also walked out towards the end. What does this say about the opposition groups in the country?
The opposition needs some orientation on how democratic politics is exercised in a country where democracy is still very young. If you start doing things you would have done in a mature democracy, but doing them in a democracy that is still very nascent, I think it doesn't work. We have to patch up. There are many things you have to put up with. All the sides have to do their side of the bargain. Because if you ask yourself, what was the advantage for them moving out? What did it help? Because whether they moved out, the law was passed. Whether they didn't move out, the law would still have been passed. In circumstances like those, you get there and have your say recorded on the Hansard, so that first of all, history judges you well, but also if there is any effort to go to the courts of law, there is this evidence you can say, this was the point that was justified and it was ignored. Oh, this is when most of this is when the nays had it and the speaker misinterpreted that as to mean the ayes had it. So if you are not there to have your say in terms of raising the voices for the nays, and you left only the ayes to have it, then they will have it. So I think that the time has come for the opposition politicians to understand that, let us know our expectations and understand that this is a stage we have to go through as a country. Democracy is still young, and democracy grows. And when it is growing, it goes through these challenges. We do not have a democratic culture that is ingrained in the hands, in the minds of Ugandans, because now at least there is a acceptability within the population that let's continue with the practice of elections after 5 years. Never mind the substance of the elections. So we are now still working on the form. What we have is elections in the form. So now we need to start working on the substance, and we need time to do this. Working out of a discussion like that one, a highly contested discussion like that one, I don't think helped.
Does the passage of this bill into law mean going forward?
We expect the continued, prosecution of civilians in the military courts. And the kind of evidence that is always presented to the military courts to justify why citizens are taken there are flimsy. So we expect this to keep happening. But the other thing I expect is some censorship of sorts on the part of the opposition, supporters and candidates, well knowing that any mistake now will have them be prosecuted under the military court.
Does this mean that now people are going to be scared and they're not going to engage in subversive activities?
We don't engage in subversion here. The only subversion we know is that which the regime has defined. So just a voice of dissent. Like now, when you are critical, they will say you are engaging in actions that we think are treasonable. So it's them to decide. So if you look at most of the young men that were taken there, for example, if you are found in a custody of a red belly, or you've put it on, first of all, the material in which it was tailored is not a military material. It is only the color. The badge on it is not a UPDF, Uganda Peoples Defence Forces badge. So just that something looks like that does not warrant you. Let me say this as well. There has been a few young people who have liked to dress in some camouflage of sorts. There are those dresses that look like military dresses with that camouflage, but they are not really. And the youth have been putting them on. These will find themselves in the military court martial. The citizens, I'm sure, will be scared. But I think the opposition will continue. The politicians that want to continue opposing will continue doing so. Because, a few of them have had their skins hardened a little bit. So they should not be able to scare them, because it will not be the first time, neither the last.
Thank you so much for your time.
Thank you very much, Paul. It's been a pleasure having me, and looking forward for another interaction.
And hey, we want to hear your thoughts. Drop us a comment in the comment section below. Tell us what you think about this controversial bill that gives military courts in Uganda the power to try civilians. Don't forget to like, follow, and subscribe to Paul Ndiho on X, Instagram, Threads, Facebook, LinkedIn, Blue Sky, and YouTube.